students, today I'm going to speak to you about Article 14 of the Indian Constitution. There are a few important aspects of Article 14. Firstly, that it seeks to protect persons, which means that the scope of Article 14 includes within its ambit individuals, irrespective of whether or not they are citizens of India, as well as legal entities, including corporates and statutory organizations and companies. Furthermore, there are two aspects of Article 14. One, equal protection of the laws within the territory of India, and equality before law. Equality before law has been a concept that has been taken from the Constitution of the United Kingdom. It seeks to ensure that everyone who is an equal is treated equally before law, which means that there will not be any special privileges granted to someone when they are before the law, and the law will apply to everyone uniformly. This brings us to our first case. In this case of State of West Bengal versus Anwar Ali Sarkar, we have seen that Section 5(1) of the West Bengal Special Courts Act was challenged by the respondent. Under this legislation, the West Bengal government had the indiscriminate right to refer any matter to the Special Courts Act, to the special courts. And when Section 5(1) was brought into play, there was a separate procedure to deal with the trials of these particular offenses. Under the Code of Criminal Procedure, there is already a well-established procedure relating to the nuances of a trial. However, without any reasonable classification and a reasoned order, it was decided that a separate procedure to fast-track cases would be established under the Bengal Special Courts Act. The Honorable Supreme Court held in this case that this particular procedure was arbitrary and contrary to Article 14 of the Indian Constitution, because there was no reasonable classification for subjecting certain individuals to a particular procedure of trial, while another set of individuals would be subjected to another procedure of trial. Hence, this establishes equality before law as envisaged in Article 14. In the case of Srinivas Theta versus State of Tamil Nadu, we see a different approach that has been adopted by the Supreme Court, wherein it was held that the petitioners believe that the entertainment tax policy of Tamil Nadu was contrary to Article 14 was rejected. In this particular instance, the amendment of 1978 to the entertainment tax was challenged. Prior to 1978, entertainment tax was levied based on the admission system, which meant that entertainment tax is an indirect tax which is levied based on the number of people who were admitted to the theatre on a particular day, or to simply put it, the number of tickets sold. However, after the amendment, it was observed that now the municipal districts would follow the admission policy. However, after the 1978 amendment, it was decided that the municipal districts of Madurai and Chennai would follow the admission system of entertainment taxation, whereas the rest of the state of Tamil Nadu would follow the committee system of entertainment tax levy, which led to the particular case coming to the Supreme Court. It was held by the Honorable Supreme Court that when it comes to making legislations relating to taxation, the purpose of the legislation is twofold. Firstly, it is to generate revenue for the country. Secondly, it is also to bring about a change in the inequalities and to bring everyone at par. This brings us to our second aspect, equal protection of law. This particular concept has been adopted from the 14th Amendment to the American Constitution. And with this, let us see how equal protection of law is brought about in the case of Baswaraj versus the Special Land Acquisition Officer. In the case of Baswaraj versus the Special Land Acquisition Officer, the Supreme Court has gone at length to explain under what circumstances can delay be condoned in filing of a petition. And also it has explained that the Limitation Act is a matter of public policy, and equal protection of law is not a unilateral right that accrues only to the petitioner. Therefore, while dealing with condonation of delay, one must ensure that delay has been caused by no fault of the petitioner. The petitioner has been active and has been diligent in pursuing all his legal remedies. However, in the present case, there was no such reason for the petitioner to be sleeping on his rights, and, despite being negligent, he had approached the Honorable Supreme Court for condonation of delay. That is why the Supreme Court rightly held that when it comes to granting protection under Article 14, equal protection of law would ensure that one approaches the court with clean hands, and only when one is non-negligent in their performance of duties, and despite that they have failed to reach the court on time, only then will they be allowed the remedy of condonation of. Hence, to summarize, the right of equal protection of law is a positive concept and not a negative right that accrues on a petitioner. In the case of Stephens College versus University of Delhi, equal protection of the laws was now read to be a positive obligation on the state to ensure equal protection of laws by bringing in necessary social and economic changes so that everyone may enjoy equal protection of laws and nobody is denied such protection. In this particular case, St. Stephen's College had deviated from the admission procedure as prescribed by the University of Delhi, despite being affiliated to University of Delhi. The question that came up before the Honorable Supreme Court was that while being affiliated to University of Delhi, does the protection of being a minority institute under Article 30 subclause 1 of the Constitution of India cease to exist? This particular assertion by Stephens College regarding being a minority institute was neither accepted nor denied by the University of Delhi, and therefore the Supreme Court, while going through the material submitted before it, was of the conclusion that Article 30 subclause 1 would supersede the University of Delhi Act. Moreover, there was no particular provision in the Delhi University Act which could abrogate the protection enshrined under Article 30 subclause 1, which is the Stephens College would continue to be a minority institute while being affiliated to the University of Delhi, and it was right in having deviated from the procedure established by the University of Delhi because that particular deviation did not lead to the circumvention of the circulars of University of Delhi. Article 14 seeks the enshrinement of law within the Constitution of India. Rule of law is a concept propounded by Dicey. The concept of rule of law has been enshrined in the Constitution by Article 14. This concept was propounded by Dicey, and we also see that the Upanishads in India have adopted rule of law. Therefore, rule of law has been the backbone of Indian legislation, not only through inspiration from foreign legislation, but also through our Indian history. Rule of law states that no one is above the law. It guarantees equality before law, and it has the concept of uniformity before law, which means that it seeks to bring about a reasonable classification in how law would apply to a certain sex of individuals who are equals within that class. And we also see that the scope of rule of law has expanded over a period of time, such that in the case of Keshwanand Bharti versus the state of Kerala, 13 judges of the Supreme Court unilaterally held that rule of law is part of the basic structure of the Indian Constitution, and no amendment to the Constitution can be brought about such that the concept of rule of law is diluted or abrogated. Moreover, we see that rule of law is also protected in Article 21 in the expanded version of the various judicial. Moreover, we see that rule of law is also protected and propounded by Article 21. There are various judicial proceedings which have envisaged that rule of law is an integral part of right to life. This brings us to the final facet of Article 14. Article 14 seeks to protect individuals and guarantee them access to justice. By right to equality, one must also ensure that one has the opportunity to access justice, which means right to appear in court. Government should have a role to play in in providing access to justice. How does the government do this? The government has various schemes. At the central level, we have the NALSA, and at the state level, we have DALSA, which is the legal aid scheme, whereby any indigent or any individual who in fact lacks the means or the knowledge to approach a lawyer can approach the legal aid department, and a lawyer would be appointed for them. This has also led to various reforms in the judicial system. We see the concept of lok adalats coming into play, wherein justice is accessible without the procedural technicalities associated with litigation. The scope of access to justice has expanded over a period of time. Gradually, we see an interplay between Articles 14, 19, and 21, which has often been known as the Golden Triangle of the Constitution. Through various judicial precedents and judicial review, the scope of Article 14 and 21 has been read together and expanded. One such case is access to justice for transgenders. In the case of NALSA versus Union of India, the word person and was interpreted by the constitutional bench of the Supreme Court, and it was held that person was a gender neutral word above and beyond the concept of male and female and included transgenders. Therefore, transgenders were recognized as a third gender for the first time following this judgment. This has led to a lot of rights accruing to them, beginning from the right to identity, the right to work, and this has led to social justice for transgenders. Similarly, we have seen in the Navdeep Singh Johar case, where Section 377 of the Indian Penal Code was read down, and it has led to recognition of the LGBTQI community. While concluding, one must emphasize on how there is no equality in illegality. This leads us to the case of Baliram Prasad versus State of Bihar. Baliram Prasad was aggrieved by termination of his service because he was accused of having defrauded his society of rupees 21,000. It was his contention that there were similar people who had defrauded the company or the society of 21,000 rupees or a similar sum, and these people were not terminated, whereas Baliram Prasad was singled out and terminated. The Supreme Court held that the Patna High Court was right in not reinstating Baliram Prasad because Article 14 does not envisage a negative right of equality to accrue to an individual, and anyone who has committed a wrong would be liable for punishment. When we speak about Article 14, we also must speak about some exceptions to Article 14. That is, in the form of the parliamentary privileges that accrue to the executive, which means that they will not be prosecuted while they are in office. Thank you.